Good afternoon, greetings, and welcome to the Quarles and Brady LLP webinar entitled New Laws Impacting Business, Arizona Paid Sick Leave and Minimum Wage. My name is Rob Vaught, and I'm an attorney practicing in the Labor and Employment Group at Quarles and Brady. As part of my practice, I counsel human resources and risk management personnel regarding Title VII, the ADEA, family leave, the ADA, OSHA, wage and hour matters, hiring and discipline, and wrongful discharge complaints. My co-presenter today is another partner here at the firm, Marian Zapata-Rossa. Marian focuses much of her practice representing employers before a variety of government agencies, defending employers in arbitration, mediation, and litigation, and providing employment advice and counseling to employers on current trends and compliance with state and federal employment laws. We have, for everyone listening, just a few housekeeping items to go over before we begin the formal presentation. We will be applying for 1 hour of CLE credit. If you are an attorney and would like to receive CLE credit for attending today's program, please fill out the CLE form located at the back of the PDF copy of materials that are found in the handouts panel of the webinar dashboard. Please complete that form and return it to Shona Boyd here at Quarles and Brady. Her contact information is listed at the bottom of the document. A few additional items for our webinar participants today. We have muted all of the phone lines for those dialing in and for participants listening to audio via their computer, so you'll not be able to speak. We're in listen-only mode here today. We would like you to be aware also that this presentation is being recorded, and an electronic survey will be mailed to you after the program concludes. If one of our webinar participants has a question, please send it to us. You can type your question into the Q&A box that's located in the upper right corner of the webinar dashboard and submit that directly to us. Our conference host here will be sure that we receive the questions. We will repeat the questions once we give them and then give everybody answers. So please do feel free to submit questions during the presentation. We will get them and we will do our very best to answer all of the ones we receive. And don't feel like you need to wait to the end of the presentation to do that. If we say something and you want to fire off a question, please do that. So with that, I will turn it over to Marian to get us started.
Thank you, Rob. Good afternoon, everyone. During today's presentation, we're going to be covering laws that impact Arizona employers. We're, of course, going to be starting with the Fair Wages and Healthy Families Act, and we're going to be primarily focusing on the paid sick leave component of that act. We want to make sure that after today's presentation, employers feel apprised of what's required for them to be in compliance with that act, but we also want to highlight some risk areas or some gray areas in the law so that you're able to assess risk as you're gearing up for getting your organization into compliance and making informed decisions in that regard. And then finally, we're going to round out the presentation by giving you a quick status update on the latest status of the Department of Labor's overtime rule. I would imagine that many of you have put the Department of Labor overtime rule out of your mind ever since the federal district judge in Texas granted an injunction which prevented the rule from going into effect last fall. You probably haven't thought about it since, but we're going to provide a status update on that at the end because it still is out there in the world. Let's launch into our first topic, the Fair Wages and Healthy Families Act, also known as Prop 206. For anyone who participated in the November election here in Arizona, you had an opportunity to either give Prop 206 a thumbs up or thumbs down. It, of course, passed. It passed in our state by a margin of 58% in favor. And it wasn't, however, without legal challenges. Shortly after Prop 206 passed, it was challenged by the Arizona Chamber of Commerce and various other business and chamber organizations that challenged the constitutionality of that law. They requested that it not go into effect as of January 1st, but that request was denied, and of course it became effective January 1st. The matter was later argued up to the Supreme Court, but the Supreme Court also unanimously found in a quick decision that was issued just 5 days after the oral argument hearings on that matter that, in fact, it was constitutional. So now the Fair Wages and Healthy Families Act has not only been passed by the voters, but it's overcome legal challenges and is now effective law in our state. There are two major aspects of that law, the minimum wage aspect and the paid sick time aspect, and we're going to cover both.
And we'll start with the minimum wage portion of the law, which I think is a little more straightforward than the paid sick time portion that we'll be spending more time discussing today. But as I'm sure we all know, if we have employees here in the state, beginning on January 1st of this year, the minimum wage in Arizona increased from $8.05 an hour to $10 an hour. There are a few coverage exceptions in the law. The new provisions don't apply to state employees, employees of the federal government, or employees of small businesses. And this is a specific exception that the Act has for employers who may qualify here in the state. In order to qualify for this exception and be exempt from the minimum wage requirements of the law, an employer has to have less than $500,000 in gross annual revenue and must also otherwise be exempt from having to pay a minimum wage under the Fair Labor Standards Act. And the Industrial Commission has taken the position, and I think it makes sense, that this small business exception to the minimum wage requirement is really pretty narrow. And most employers, not all employers, but most employers aren't going to be able to claim the exception under this provision, because essentially to be excused, with a couple of exceptions, to be excused from having to pay minimum wage under the Fair Labor Standards Act, you essentially have to be a business that doesn't engage in interstate commerce. So if you do things like use the internet to conduct your business, or use a telephone to conduct your business, or send or receive mail to conduct your business, not to oversimplify it, but chances are you are going to be found to be engaging in interstate commerce, and you're going to be subject to the minimum wage requirements of the Fair Labor Standards Act. So it's important to know that the small business exception is in the minimum wage portion of the law, but chances are few businesses will qualify. The law also contains predetermined increases for the minimum wage. Next year it'll go up to $10.50 an hour. In 2019, it'll be $11 an hour, and then in 2020, it's going to increase to $12, and then beyond that, it's set to increase tied to cost of living. So there are some lockstep increases that have already passed as part of the law, and then after 2020, it'll be more variable, I think. The minimum wage law also, for those of you who have tipped employees, the law also says employers can still take a tip credit. So while the minimum wage changed, the number changed, your ability to take a tip credit for your tipped employees didn't change. So employers in the state can still give a credit to their tipped employees of up to $3 an hour, so long as that with included tips they don't fall below the minimum wage. And of course there are separate notice requirements and other things you have to do to be able to take advantage of the tip credit, but the law that passed and became effective here in Arizona this year still gives you the authority as an employer to take a tip credit if you've got the right kind of employee.
Turning now to the second component of the Fair Wages and Healthy Families Act, the paid sick leave component, which is primarily where we're going to invest our time during today's presentation. Presently in the United States, there are 7 states plus the District of Columbia that have paid sick time laws on their books. What's interesting, however, is that unlike the other states in that category, Arizona tends to stick out because Arizona really is viewed as a pro-employer state and a state that's not heavily regulated in terms of employment laws. The other states are states that you would expect to have those types of laws on their books, states like California, Connecticut, Vermont, Washington, Massachusetts, and DC. What else is interesting about Arizona's law is that in terms of who's covered under the law, Arizona tends to be one of the broader laws as compared to the other states. In Arizona, all private employers are covered under the paid sick time requirements. The only entities that aren't covered under our law are the U.S. government and state government workers. But local government workers are covered, and all private employers are covered. Now, with respect to employees, our law is also very broad. Our law applies to all employees regardless of whether they're full-time or part-time, regardless of whether they're classified as exempt or non-exempt under the FLSA. In fact, the definition for paid sick time of employee is any person employed by another person. So short of individuals who are employed for parents or employed by parents or siblings, or who are providing casual babysitting services, all other employees are covered. And interestingly, that is a broader reach than even laws in California or Connecticut and or Wisconsin or Washington, excuse me, that actually have some limitations based on certain industries or have some limitations based on the hours that employees are working. Our law has accrual ratings that are somewhat similar to those in the other states. And what our statute provides is that beginning July 1st, 2017, all private employers in the state of Arizona have to start allowing their employees to accrue 1 hour of sick time for every 30 hours worked. Now, the law specifically says that if an employer has an existing policy that provides a sufficient amount of leave and it meets the accrual requirements, is available for the same purpose and under the same conditions as required under this act, that an employer can use their existing policy to cover paid sick time. Many times employers will have sick time policies or PTO policies that are tiered based on employees' tenure or different classifications, such as whether employees are exempt or non-exempt. And arguably speaking, so long as the lowest tier is no less than an accrual of 1 hour for every 30 hours worked, those type of policies would comply with the new law, assuming they provided sufficient accrual and employees were eligible to use them for the same purpose and under the same conditions. This begs the question, however, how to handle exempt employees. How do we figure out how their accrual rating would work when exempt employees typically don't record their hours, and they, in some cases, work less than 40 hours, in some cases work more than 40 hours, but are otherwise required to get the same paycheck, pay period after pay period. So what the statute says with respect to these employees is that employers can presume that regardless of how many hours they're working, presume that they're working a 40-hour work week, unless their normal work week is significantly less than the 40 hours, in which case you could base it off of their normal work week. The new law also provides that although all employees have to start accruing as of July 1st, 2017, employers can require that any new employees hired on July 1st or thereafter wait a 90-day probationary period before they actually start using the sick time. Now let's talk about what the accrual caps and the usage caps are under the law. So the law seems to be pretty straightforward in this respect. The law designates accrual and usage caps based on the size of the employer. Small employers with less than 15 employees can cap the time that their employees use and accrue at 24 hours per year. Larger employees who have 15 or more employees can raise that, are required to raise that cap for usage and accrual to 40 hours per year. A good question that just came in online is whether the cap, the 40-hour cap, is an annual cap or a total cap. And the way that the statutory language is written would suggest that it's an annual cap. So in year one, if you're an employer, a large employer who has 15 or more employees, your employees would be entitled to accrue 40 hours of paid sick time, a minimum of 40 hours of paid sick time. And if over time they didn't use that time, each year as they amount an additional 40 hours, that 40 hours would be on top of the 40 hours they earned in the first year. And there is no cap as to how much sick time they can accrue over time. The only cap is with respect to being able to use 40 in a year and accruing no more than 40 in a year. But over time, they could get up to 200 hours if they never use this time. Also, in order to figure out whether you're a small employer or a large employer, you'll want to consider which employees you should be counting. And the statute does provide some guidance in this respect. So the statute indicates that you should be counting all employees who perform any work for you in any given day in each of 20 calendar work weeks in the current or preceding calendar year. So essentially it follows the FLSA's accrual formula. The 20 work weeks don't have to be consecutive, but anyone providing work in that time period should be counted. What's less clear under our statute is whether you should only count employees who work in Arizona or whether you should count employees company-wide. So the statute is technically silent on this issue. The statute does provide that the Industrial Commission issue promulgating regulations, and we expect that may be the case, that those may be coming out. Now, whether they do come out before July 1st is unknown, and certainly what issues they specifically address is yet to be seen. But for now, it is unclear for employers who have workforces in other states outside of Arizona if they should be counting only the 15 employees in our state or if they should consider all employees on their payroll.
All right, carryover. I think that this is one of the topics that we probably get the most questions on from employers who are looking at the statute, trying to figure out how to actually manage the amount of leave that their employees are going to be accruing come July 1st. And the statute basically gives employers two options for managing this. Under option one, all accrued unused time has to be carried over, as Marian was saying, each year. But employees can't use or accrue more than the maximum capped amounts in any given year. So as Marian was saying, it's technically possible, given the language of the Act, for somebody to have more than 40 hours in their quote-unquote bank over the course of several years, but an employer can require that, regardless of that, employees can't use more than the maximum amount in every year, so 40 hours for the larger employers. There's an alternative option in the statute that basically says employers can pay employees for any accrued but unused sick time at the end of the year, but then they have to replenish that time for immediate use up front at the beginning of the subsequent year. So under that scenario, if you had somebody that had 8 hours of accrued but unused time at the end of the year, you would pay them out for that, get it off your books, but then you would have to immediately make available all of the time that they would be technically able to accrue under the statute up front. And really the option that employers pick is really going to depend on, what works best for your company, how your payroll is set up, how you manage other aspects of leave. For some employers, I think it's going to be a lot easier to just keep track of it as it goes along, give them 1 hour of leave for every 30 hours worked, and if they have stuff left over at the end of the year, you roll it over. I think for other employers, it will be easier to start with the max, so to speak, and let employees work down from that 40-hour bundle that you may give them at the beginning of the year, and then pay them for anything that's not used at the end of the year. It's a way to get, unused time off your books, but as we're going to see in a minute, you're not required to pay employees for unused time, accrued but unused time, if they leave your employment. I think a lot of employers are wondering if there's a possible third option, which is to go ahead and give everybody the upfront payment at the beginning of the year, but then carry over rather than pay out the balance at the end of the year. Right now, as the way the statute's written, that's not something that's provided for, but as Marian said, the Industrial Commission any day now is supposed to be issuing regulations to clarify some of these issues, and we're hopeful, at least based on questions that we've sort of received and know have been submitted to the Commission, that that's something that they at least address in the regulations that we know they're working on. And as I said, but just to follow up, employees aren't entitled under any circumstance, to be paid out for accrued but unused sick time when they leave. And that's regardless of whether they quit, it's regardless of whether it's a reduction in force, it's regardless of whether you terminate them for any reason under the sun. So that can be important when deciding how to manage carryover, because I think a lot of employers are understandably hesitant to have a situation where you have employees with massive amounts of accrued but unused sick time available. But if they can only ever use 40 in a year and you don't have to pay them out for the 200 or 300 hour bank they may have built up, the practical effect of that from a financial point of view may be less severe.
And having covered those topics, to drill down then a little bit further on the question that we received, which was, is there no cap to the total rollover? In other words, with an annual accrual of 40 hours, can an employee accumulate 200 hours total, even though they can only use 40 in a given year? And the answer, as Rob and I have explained, is yes. That's exactly what's contemplated, is that although large employers can cap the annual accrual at 40, over time, employees can carry over an amount that has no ultimate cap. And then the further question was why, which I think is an excellent question, but I don't think there's a response. I think in drafting the statutory language, perhaps it was well intending that employers would be able to get the benefit of having their their sick time either paid out or roll over, and not having to forfeit any at the end of the year. However, it's somewhat short-sighted because, as Rob just explained, there's no cash value at the end of employment, and so beyond that, it's puzzling as to why that that there is no total cap. And certainly other states that have paid sick time, such as California, have implemented a total cap. Maybe this is an area where we'll see some additional clarity or some amendments over time. Let's talk now about the uses that employees have for taking their leave. There are essentially 5 uses that employees have for taking paid sick time under this law. The law is very broad. It includes, of course, what we would expect, which is that employees can use this time for their own sickness, but even that definition is very broad. So it would encompass any illness, any injury, any health condition, whether it be mental or physical. It would also encompass not only diagnosis and care, also treatment of that condition or preventative care of that condition. The sick time may be used for any of those reasons that an employee can use for themselves. They can also use for a family member. So a family member's illness, injury, health condition, both physical and mental, including diagnosis, care, treatment, preventative care. Aside from those medical reasons, the statute, similar to other paid sick leave laws, also has an allowance for employees to use this time related to domestic violence incidents. So in our law, it could be used for relocation, for obtaining legal services or counseling services. It can be used if the employee or any of their family members are victims of domestic violence, abuse, sexual violence, stalking, and need to avail themselves of any resources such as counseling or treatment related to that. The fourth instance where our sick time can be used is if businesses or schools are closed because of a proclaimed public health emergency. So if there is a proclaimed public health emergency, we'll know it when we see it. And then finally, there's an allowance where employees may take paid sick time to use to care for a family member if that family member has been exposed to a communicable disease and a healthcare provider certifies that their care or quarantine is necessary. Now, these uses or instances when sick time can be used really are a threshold level. Employers can certainly allow employees to use paid sick leave for reasons above and beyond what the statute provides. And the statute in a couple of different places really emphasizes that point, that the law sets a floor as to what is the bare minimum that employers have to provide in this respect, but they're certainly encouraged and welcome to go above and beyond. And many employers do, whether it be because they have existing policies that are already more generous, and they don't want to affect employee morale, or perhaps because they're in industries that are more competitive, and so their benefits packages tend to just be more competitive as a whole. The statute also defines, however, who's covered as a family member, and it is a very broad definition. It includes the employee's spouse, domestic partners, their children, regardless of age. So presumably you could have grown children that become ill and you take paid sick leave to care for. And the definition of children is also very broad. It includes not only biological children, but also foster children, stepchildren, legal wards. The same for parents. It includes your step parents, your spouse or domestic partner's parents, your adoptive parents, foster parents, grandparents, siblings, and then finally a catch-all, any other family member who is related by blood or affinity, or whose relationship to the employee would be equal to a familial relationship. So it really is a very broad definition, a very all-encompassing definition.
All right, so now that we've gone over the circumstances under which you can have an employee request or take leave, what can you as the employer require from the employee to certify that they're taking time off for a permissible purpose under the statute? There is some specificity in the law about this. And when you have an employee taking paid sick time under the statute for 3 or more consecutive work days, so one right after the other, you as the employer can request what the law says or defines as reasonable documentation to validate that the employee is taking leave for a permissible, permitted purpose. Now, reasonable documentation is sort of an inherently vague term, and that's something that I'm sure is going to be fleshed out as the law becomes effective and employers kind of deal with managing this. Under the statute, what can be requested? In the case of paid sick leave for a medical or mental condition, the statute says that a document signed by a healthcare professional indicating that the sick time is necessary is sufficient. And that's pretty much all the guidance they give as far as what kind of form you may need or what kind of detail may be required. Just something signed by a healthcare professional, not a doctor necessarily, but a healthcare professional, indicating that the time off is needed. In cases of time for some of the domestic violence issues that Marian was just describing, the kinds of documentation that the statute says are acceptable are things like a police report, a protective order, or some kind of court document, an injunction, any like a subpoena or something requiring your attendance or your employees' attendance at court, signed statements from a domestic or sexual violence program service provider or an attorney. It references a member of the clergy or other medical professional who might be attesting to the need for your employee to attend some kind of event or hearing in that regard. Or the statute says the employee's own handwritten statement that the employee needs to attend something like this shall be considered sufficient. And the law specifically said the employee's own handwritten statement doesn't have to be formal, it doesn't need to be an affidavit, it doesn't even need to be notarized. If your employee comes to you with something they have written out on a piece of paper saying something like, I need to be at court tomorrow to testify at my, daughter's or family members, trial for a particular issue, under the statute that would be sufficient. The statute actually goes one step further and says that employers can't inquire into the details of the health information or inquire into details relating to the particular domestic violence issue. So not only does the statute provide relatively minimal notification as being sufficient, but you, the employer, can't ask for more details. If what they've sent you or given you is sufficient under the statute, then that's it. You still have to keep the information they give you confidential, no surprise, as you would with any other medical information that you're getting from an employee. but you can't ask for more details. And here I think that training for your supervisors or managers is going to be really, really key. Because if you've got, supervisors or managers that are going to be intaking or receiving some of this information from your employees, you don't want to be in a situation where that very well-meaning supervisor says, I need more detail here. Go back to your healthcare provider. I need to know why you're going to be out. If you start asking for that kind of detail when the statute specifically says you can't, you may run into trouble on the retaliation or interference side of things.
The statute has various notice requirements placed on the employer. First and foremost, beginning on July 1st, 2017, employers are required to post the poster, which is presently available in both English and Spanish on the Industrial Commission's website. It's available at www.azica.gov. And the poster, taking a look at it, it complies with the notice requirements that you're required to give. So you're required to tell the employees that they're entitled to the leave, the terms of their ability to use it, the fact that they can't be retaliated against, inform them how to file a complaint if they do feel that they've been retaliated against or that their rights have otherwise been violated, and the contact information for the Arizona Industrial Commission. So all of those items are included in the form notice, which is available both in English and Spanish on the Commission's website. Just like any other workplace poster, that has to be displayed in a conspicuous place in your workplace. So break rooms, other high traffic areas where employees routinely visit is where we would recommend putting that. Aside from putting up a poster, however, you're also required to provide employees with notice about how much time they are accruing. So in their paycheck or on an attachment that you can include with their regular paycheck, each paycheck you have to report to them how much time they have available, how much time they've used, and how much sick time they've been paid. And there are penalties not only for violating the other provisions of this paid sick time law, but specific penalties that attach for failing to comply with the notice or record keeping requirements. And so, part of what you'll want to do between now and July 1st is work on a mechanism, if you don't already have it in place, either with your payroll provider or with your finance team, if you do those functions in-house, to figure out how you're going to track sick time and what mechanism you're going to use to provide this notice disclosures with each paycheck. So big picture, what should we be doing? What should employers be doing between now and July 1st? There's a little bit of ambivalence around this because we're still waiting for those regulations, and presumably they're going to come before July 1st. But in any event, it's a good time now, if you haven't already started, to start looking at your policies and figure out what's going to work for your organization, how you want to meet the compliance requirements under this law. So taking a look at any existing paid time off policies that you have, any existing sick policies that you have, leave of absence or attendance policies, making sure that there's nothing in those policies that would run afoul of the new law. Easy enough, get the posters printed from the Industrial Commission website and make sure that those are appropriately displayed. And then we talked a little bit about the types of training that you'll want to conduct with supervisors. In this case, having also a tracking mechanism in place with your payroll provider, or figuring out who internally is going to handle the tracking and how that's going to be done, whether that includes creating certain leave request forms so that you're able to verify leave that's being requested and taken by employees. Now's the time. Everything must be in place by July 1st, 2017, so that as of that date, you're off to the races and employees begin accruing as of that date. And if you are not in compliance, there are penalties that attach. I mentioned just briefly the penalties for failing to record and track. it's $250 for the first violation and then $1,000 for every subsequent violation. It's a little unclear whether that would be per employee that you failed to track, but conservatively speaking, that could be the case. The record keeping requirements are in place for 4 years, but aside from that, any violations of the statute for retaliating or interfering with employees' rights to use the statute also could be subject to statutory penalties. Fines of $150 per violation. The statute also creates a private cause of action for employees to bring a lawsuit, and the statute limitations on that is 2 years or 3 years for willful violation, so it really does follow the Fair Labor Standards Act statute limitations in that regard. But the goal really is to work through some of the gray areas between now and July 1st, so that you're ready to go as of that date. And we have lots of great questions that have come in over the course of the presentation, really targeted at how do we get our existing policies into compliance. And so I think what we'll do is we'll just go ahead and start tackling these one at a time. So the first question, how will the cap work for 2017? I think that's $1 million question. Certainly there's confusion around this law because it starts mid-year. So many employers probably issue PTO or sick leave based on a calendar year, and they're now 6 months in, and perhaps they had a PTO policy or a sick leave policy that would have otherwise complied with this because it's sufficiently broad in what employees can use it for, and it allows employees to accrue enough leave that's kind of above and beyond what the statute would otherwise require. But there really is some question as to whether, as of July 1st, you have any obligation to do anything more than provide whatever policy you provided at the beginning of the year. Now, the Industrial Commission is taking calls and emails that employers have. Some of what we've been hearing from clients certainly, has given us pause about their interpretation of things. It really will be helpful to have the guidelines, the regulations in this area to better define, define what your obligations are. But at a minimum, what we can say is that starting July 1st, 2017, employees should start to accrue 1 hour for every 30 hours worked. And if you're on a calendar basis, perhaps the easiest way to administer it and ensure that you're taking a conservative approach would be to implement that 1 hour for every 30 hours worked from July through the beginning of the year. And then at the beginning of the year, perhaps you can make a more informed decision about whether you want to pay out at the end of this year and then start a new allotment up front as of January 1st, 2018, or whether you just want to allow employees to carry over and continue to accrue at the rate of 1 hour for 30 hours worked. There certainly is no one-size-fits-all response for how to make this work with your existing policies, because your existing policies really are catered specific to your workforce. And so I think the best response would be to have an opportunity to discuss and look at what options you have based on what you have in place and what your goals are for your employee benefits plan.
Another question we got is, are you saying that if your current PTO is more generous than the law, employees still can't accrue or use more than 40 hours? And the short answer to that is no. I mean, you can certainly, as Marian was saying, be more generous than the law provides. The law just says that employers have the option to cap use and accrual at 40 hours for those larger employers. So if your current PTO is more generous than that, that's fine. And the law isn't saying you have to change your current policy. As long as your current policy allows employees to accrue at least the rate described in the law and can be used for at least the purposes that are provided for in the law, then that's good. So you certainly, as an employer, can be more generous than that. And if your current PTO policy is, then that's fine.
Another good question that I think we can really drill down on is, what if you have an existing policy? Do you have to, based on this law, separate an existing PTO policy out to sick time and vacation time? And the answer is no. You can leave that existing PTO policy intact so long as it, and the statutory language requires that, so long as it provides a sufficient amount of leave, so long as it meets the accrual required under the law, and it can be used for the same purpose and under the same conditions. So if you have an existing PTO policy in place, but it doesn't meet the carryover or accrual, those would be areas that you would want to tweak to bring it into compliance. And then another good question, sort of related, is if you had a policy in place that started as of January 1, how should you handle sick leave that's accrued as of July 1st? In other words, can you count what employees were allotted from the beginning of the year toward the accrual cap of 40 hours now required under the law? So the statute is silent as to this point. I think it certainly would be an area that would create exposure for employers. I think plaintiffs' counsel might look at those types of policies as maybe right even for potential class action type implications. So hopefully the Industrial Commission will shed some additional light on this, but definitely there could be some risk if you have an existing policy that you allotted at the beginning of the year and you don't add anything further as of July 1. And the risk really takes the form of this. So if an employee was granted their PTO that they could use for any reason as of January 1st, but they took it all in either vacation or personal days, and then come July when they're supposed to start accruing this new leave, they're now sick, or their child or spouse is sick, and they don't have any leave available to take, I would bet that these are the types of employees that are going to find plaintiffs' counsel or lodge complaints with the Industrial Commission. And our goal would be to keep our clients from becoming test cases where these issues get flushed out. So taking that approach, it's unclear, frankly, whether that would be allowed or would not under the statute, but certainly it's probably an area that could create exposure.
All right, another question is, if you're using your current PTO policy to satisfy the requirements of sick leave under Prop 206, as the hours under sick leave appear to continue to accrue ad infinitum, does that mean that we cannot cap the hours of total PTO an individual can accrue? The short answer to that is no. I mean, if you have PTO that you provide in your policy that is used for stuff, other than the types of leave that's provided for in the statute, this particular law, it doesn't necessarily speak to that. Once, as of July 1st, when this kicks in, you can cap the hours of paid leave, regardless, I guess, of technically what you're calling it, that employees use for any purpose that is enunciated under the statute. And a lot of employers are really taking a hard look at their PTO policies, because Prop 206 doesn't talk about vacation time. It doesn't talk about personal days. It doesn't talk about those more traditional kinds of paid leave that some employers offer. So you certainly can combine your policies, your existing policies, and this new requirement into one policy. What's clear is you do not have to have, as an employer, a separate Prop 206 policy with a separate bank of potential paid sick time that can be used for the things that Marian talked about. You can combine it into one policy. You don't have to give them a separate bucket, so to speak.
Right. So this is definitely an organic area of law, and we'll hopefully start to get some additional insight from ICA in terms of how they're going to construe, and implement the statutory language. But Certainly, this is an area where I would be picking up the phone and calling council, and I hope that that you will, as these questions arrive, because we really do think that they are contingent, kind of on a case-by-case basis. And of all the policies that I've looked at for various clients, I can tell that even thus far, I have not drafted 2 policies that have ended up looking the same. There is no off-the-shelf way to address this. It really should be a solution that fits your business and your workforce. So we'll continue to ask those questions as they roll in, and thank you so much for submitting those online. But we do want to make sure that we're able to round out the last portion of the presentation and provide the update on the Department of Labor's overtime rule.
All right, so these proposed changes to the FSLA overtime exemptions got a lot of press and media attention last year. They've been talking about doing this for a while, but as we all, I'm sure, recall, the Department of Labor announced a final rule back in May of last year that increased the minimum salary threshold for employees who could be considered exempt from the overtime requirements under those what are called the white-collar overtime exemptions, the professional, executive, and administrative exemptions that apply to a lot of managers and other managerial type level people in your workforce. The old salary threshold was about $23,000. The department had proposed increasing that to just over $50,000. The final rule settled on a new threshold of $47,000, $47,476, and provided that up to 10% of that of non-discretionary bonuses and incentive payments can be counted toward that cap. So it was slightly lower than the original proposed by the Department of Labor. The new rule also increased the salary threshold for people exempt under the highly compensated employee exemption. That was increased to just over $134,000. And basically what that meant under the new rule, as we all know, that if you had an employee, regardless of what duties they were performing, who earned less than $47,476, that person would be entitled to overtime, which was a big change. It was supposed to go into effect on December 1st of last year, and the final rule also included some automatic updates that were supposed to have taken effect. And the stated purpose of the new rule was really to modernize the overtime regulations. That salary threshold hadn't been updated since the early 90s. The argument was it really hadn't kept up with inflation, and the Department of Labor looked to a big portion of the workforce, line level managers, assistant managers who may have been exempt that were earning $30,000 a year, working more than 40 hours a week but not making overtime. And the department estimated that millions, there were estimates sort of all over the place, but millions of current exempt workers or then current exempt workers would have become entitled to minimum wage and overtime protection unless their wages had been increased. It did create a bright line test based on salary, and the effect of that was that it was going to be increasing pay for workers either through boosted salary to keep them at the exemption or overtime eligibility, and also to reduce overtime.
And so these changes were scheduled to affect the white-collar exempt categories. And so just very quickly, as a point of reference, those that would be affected would include the executive exemption, administrative exemption, professional exemption, and highly compensated employees. And on the next various slides, we provided a thumbnail of what those definitions are, because not only does the fact that this is ongoing present an opportunity to address employee salary and overtime, but really this presents an opportunity for employers to look at their classifications and revisit perhaps if there are any classifications that are incorrect. This would be a good time, a natural time to go back and revisit those and bring those into compliance. And so just very quickly to go over what those exemptions are. The first exemption, executive exemption, these are basically your managers. these are the folks who are managing your company. They're regularly and customarily directing 2 or more employees, so these are your supervisors. They're the ones who have the authority to hire and fire and take other adverse actions against your employees. The administrative exemption, this is your administrative staff, your office employees, all the folks that are involved in your day-to-day management or general business operations. So folks in your HR managers, your financial services employees, folks doing advertising. These folks have to have the ability to exercise discretion and independent judgment in making decisions with respect to your organization over topics that are matters of significance. Those folks would be affected. And then finally, the professional exemption, and this just covers folks who also exercise discretion and judgment in their day-to-day performing their job functions, but they really do have to have knowledge of an advanced type in a field of science or learning that's customarily only acquired by prolonged specialized and intellectual instruction or study. So these are the folks that are covered in addition to your highly compensated folks. And we shall still see what ends up coming of this decision. We'll talk about the current status of it in just a moment, but I really want to just impress the point that this is an opportunity to go back and review your job descriptions and your job classifications. And if you have folks who are misclassified, this presents the opportunity to bring that into compliance.
And, a lot of people, including, many of your clients or maybe some of you even listening, last year when we thought this was going to go into effect on December 1st, changed the way they were either classifying or paying their employees to get into compliance, and then all of a sudden they didn't have to go into compliance. So, and a lot of employers are still sort of considering how they might be able to comply with the rule, assuming that it may go into effect. Employers can still call upon, employees at any time of day. That's not changed necessarily under the proposed new rule. A lot of employers, as Marian was saying, we're looking at, how they're classifying employees as exempt or non-exempt. If this is still sort of an analysis that you're going through or your clients are going through, it still is a good time to consider adding job responsibilities for, some of these exempt employees to, make sure that they qualify at least under the duties test. If you want to keep, your exempt employees exempt who are making less than the salary threshold in the new rule, you can keep them exempt as long as you increase their salary, and a lot of employers did that. And said to their frontline managers or other people that were making around $30,000 a year, you're getting a raise and you're still going to be considered exempt. Or the kind of alternate common sense option was to keep them at their current pay and pay them overtime. We're not going to necessarily increase your pay, but you're now going to be considered an hourly employee and you'll be entitled to overtime. And in some cases, employees were happy about that because depending on how much they were making, it meant that they were going to be getting overtime. A lot of other employees, sometimes we've heard, didn't like hearing that they were sort of being taken from a quote-unquote salaried exempt status to an hourly status. A lot of employers, this also forced them to really look at their overtime and think about ways they could reduce or potentially eliminate overtime work. Or reduce base pay to absorb some of the increased costs. So a lot of employers already sort of went through this analysis and were ready for the change to take effect, and then it didn't. So the current status, as Marian alluded to earlier, back in September, a lawsuit was filed in Texas by 21 states and a lot of other business groups, arguing that the new rule improperly increased the level without looking at what the employees were actually doing. They said that the new rule just imposed a bright line salary test and that was it. In somewhat of a surprise decision, the Texas judge issued an injunction saying that the rule wouldn't go into effect on December 1st, and basically that injunction was applied nationwide. So it didn't just apply to employers and employees in Texas, it applied throughout the United States. That decision was appealed to the Fifth Circuit, which is where it's remained today. And the outcome of that appeal isn't really clear. especially given the new administration. I mean, it was the Obama administration's Department of Labor that, pursued the rule change, was involved with the case before the election. It's a different Department of Labor now. And so whether or not that appeal gets pursued, whether the department puts resources behind it, remains to be seen. If the injunction is reversed on appeal, it is possible, and it remains sort of an unsettled question, I think, that an employer could be liable for the period between the original December 1st effective date and the date of the appellate reversal. Courts are kind of split on that. Some courts in similar circumstances have said, if an injunction gets reversed, then the law becomes effective retroactive to, in this case, December 1st, which means if you didn't prepare for the change and adjust your employees' salaries or duties, you could be liable for overtime. Other courts have said in similar circumstances that no, the rule doesn't apply retroactively. It only applies as of the date of the reversal. So there is this sort of, I think, open question as to A, what will happen, if anything, to the appeal, and then B, what's the potential financial liability for employers that didn't make the changes prior to December 1st.
And then very quickly, because we did get some really good questions about the paid sick time that we want to get back to, but just really quickly, so here's the current status. The Department of Justice, representing the Department of Labor, requested from the Fifth Circuit that their due date to file their brief be extended. It was originally extended to some point in February and now has been pushed back to May 1st. So they have until May 1st to file the brief. Of course, the former candidate for the Secretary of the Department of Labor, Andrew Puzder, withdrew. Now they're vetting a new individual, Alexander Acosta. It's unclear, how that process is going to pan out and how long it's going to take before there's even a head of the Department of Labor in place. So certainly, putting the brief on hold made sense, and that was an unopposed motion. What's interesting, however, is that at the Texas District Court, the case is still ongoing, and so presently motions for summary judgment have been filed and they're pending. And although the parties requested that the District Court stay its action pending the Fifth Circuit's appeal, the District Court declined. And so it really may be the case where the Texas judge issues a decision on the motion for summary judgment before we get to May 1st and the brief is ever even filed. So what else can we expect? I mean, from the administration, there's certainly a number of actions that can be taken. The appeal can be withdrawn. The pursuit of the overtime rule can be changed in a different trajectory altogether. Certainly, it's unclear how the Trump administration will proceed, but there's a good inclination to believe that, like other executive orders and pursuits under the Obama administration, that the Trump administration would try to backpedal or unravel the current action, and so the likelihood that employers will be on the hook for that period of back wages, assuming they're in a jurisdiction that has found that the back wages would be due, that risk is probably low, but it is still out there, and it's certainly something that we're keeping an eye on. But with that, let's jump back to, I think, really the meat of today's presentation and make sure that we get all the questions that we have coming in online answered for you. So another question that we got was, will you please explain more about commissioned employees and how will the 90-day look-back period work? So what we know for commissioned employees is that their commission and other types of compensation can be factored into determining whether they've been paid minimum wage in Arizona. The administrative nightmare, I think, is that every work week you would have to calculate commissions coming in and calculate what the difference would be, if any, between the commissions and otherwise what it would take to get them to minimum wage, and supplement that on a work week basis. Otherwise, commissioned employees, just like all employees, are subject to the second aspect of the law, which is the paid sick leave law, and they would accrue it based on hours worked, just like just like everyone else, whether they are exempt or non-exempt. Now, the 90-day look-back period. Actually, Rob, you want to talk a little bit about the 90-day probationary period?
Yeah, and I wasn't sure if this particular part of the question, and forgive me, dealt with sort of the 90-day look back for determining what you've got to pay a commissioned employee for every hour that is taken, versus the probationary period. And I think it's Marian explained kind of the former, but the latter is that while the statute's pretty clear that employees have to start accruing time come July 1st, you can have for new folks a 90-day probationary period on use. We get asked a lot, or I've been asked a lot for people that have sort of temporary workers. What if we have somebody that works for 20 days, leaves, and then comes back, within a 9-month period? And the statute says that if you've got an employee who leaves and comes back within 9 months, they basically pick up where they left off. And I think that in that case, rather than requiring that person who comes back within 9 months to start the clock again on the 90-day probationary period on use, they'd be entitled to credit essentially for the 20 days or however long they worked with you to begin with.
Okay. Another question: if we front load the sick time each year, do we have to allow employees to carry over unused time and add that to the new 40s? So this really is answered on our slide that Rob covered, talking about the carryover and the two options that employees have under the statute, the way that it's presently written. So employers can, under the second option, front load sick time at the beginning of the year, and then they're required to pay it out at the end of the year. Come January 1st of the subsequent year, they front load another allotment, which would arguably be the 40 or 24 hours, depending on the size of your company. What is unclear is if employers can do a third option that Rob explained, which is, can we front load it, but then at the end of the year, rather than carry it over, or rather than pay it out, can we just roll it over? It's unclear based on the statutory language if that's allowed. Certainly, we could raise some arguments that there's no forfeiture there, and so employees their rights aren't being interfered with in any way, and they're being provided what they expected to receive under the law. But because that third alternative is not explicitly written in the statute, it's unclear whether ICA would think that flies.
And we're coming up on an hour here. We've got 2 more questions we can get to quickly. One is, if leave were to be kept in a combined PTO policy, does the amount of time used for sick time still have to be tracked separately? And I think if you look at the statute, the answer to that is yes. And not necessarily sick time. It's paid time used for any use permitted by the statute. So not just sick time, but if the kid's school is closed by a public health official and you've got to pick up the kid, or it's a hearing related to domestic violence or sexual assault, any of the permitted uses under the statute, the law says that you do have to track those separately. How you do that is going to depend on what your pay stubs look like and the kind of information that you give employees. I mean, I don't think it's necessarily true that you have to have a separate box saying this is the Prop 202 tracking section of your leave, but you at least have to have that information recorded and given to the employee, in accord with what's required in the statute.
Right. And it really is going to depend on how you want to administer the policy. So if you really do want to cap sick usage at 40 hours, then you would want to track employees' usage of sick time separately, even under a combined policy. I would presume that employers that have a combined policy are probably looking for the easiest way to administer it and make it foolproof so that there's the least opportunity for error and risk. And so while we don't know for certain, presumably it would be fine under the statute to have a designation on your paycheck that says PTO, and it breaks out, the specific requirements that are required in the statute. So how much you have, how much you've used, how much you've paid, and that's called PTO, as opposed to PTO with a subsect of vacation, with a subsect of sick time. Now the last question, we actually have a few more, and we're happy to stay, but we don't want to keep anyone else. if they need to log off on the hour. So as Rob said during the housekeeping introductory portion, you will be receiving a survey and a link for obtaining CLE credit for those of you that have to leave. Thank you so much for participating with us on this webinar. It was our pleasure to have you, and we do appreciate all the questions. For anybody who would like to stay, we have a couple more that we're more than happy to answer. So the next question is, we're adding paid sick time accrual 40 hours to our existing PTO policy. If we require employees to use paid sick time in qualifying circumstances before they use PTO, are we exposing ourselves to risk? The answer is possibly. So there's case law, certainly not on our Arizona law since it's brand new, but there is case law generally about employees' use of FMLA and employees' use of paid time off in the Ninth Circuit that provides that it's employees' prerogative whether they want to use it or preserve it, even if they're taking leave for a qualifying reason. So it's possible that that type of case law would be viewed as persuasive in this instance, and maybe employees would argue that they can't be forced to use their paid sick time just because they're taking leave for a reason that qualifies under the law. Maybe they would argue, I want to take it as unpaid and save it for down the road because I know I have a major surgery coming up or something along those lines. So, so it's possible. You know, my recommendation in that regard is to make sure that you have a policy that's very clear about what your expectations are. Certainly that's what's required under the FMLA. If you're going to require employees to apply PTO to run concurrently with FMLA leave, you know, it's very explicit under the statute that it has to be designated as such, and that employees have to be provided notice of that in their policy. And so I think taking a similar approach, short of getting any additional guidance in this area, is probably you know, a good approach to take, where employees are provided notice about what the expectations are, and you're disclosing to them in advance, you know, when they'll be required to use it or when they may be allowed to use it.
All right, and the last question we've got says, if my company combines bereavement with sick leave and we offer a maximum of 40 hours per year, do we have to separate the two after July 1st, 2017, since we have to ensure that employees have the minimum time available of 1 hour for every 30 hours worked? We allot the full 5 days on January 1st for the full year. It wouldn't be unusual for someone to take 3 days of bereavement leave by February and then only have 2 days left for illnesses for the rest of the year. The short answer to that question, I think, is yeah, you would have to separate it because, you know, the statute doesn't speak to bereavement leave. That's not one of the permitted uses. So I'd be real hesitant if I'm an employer to say, well, we currently combine it. You know, in this situation, if you have an employee who takes 3 days off pursuant to a bereavement policy, you know, that's not a permitted use under the statute. They'd still be required or able, I think, to take, you know, their full amount of time, you know, under the statute for sick leave. So I think that might be an instance where it doesn't, you know, need to be in a completely separate policy. Maybe you deal with bereavement separately. But, you know, the thing to remember here is that these employees have to, you know, accrue and be permitted to use paid sick time for events that qualify under the statute. And if you're, you know, if you're deducting anything from that and calling it bereavement leave or something else, that I think you'd be running into problems there.
Yeah, and particularly, I think this is a problem to start us off in this first 6 months. And you know, a good question that I think is worth raising is, why on earth did they start this July 1st and not just start as of January 1st, so that employers, you know, wouldn't have this quagmire of figuring out whether leave allotted at the beginning of the year could be counted toward it, or whether they have to start anew with another allocation of leave as of mid-year. So the answer is, I think that actually many of the statutes across different states start this way, and I think that the purpose that they're trying to accomplish, although we can only glean, is they're trying to have employees accrue a sufficient bank so that they're not starting with nothing. So that if employers don't provide the allotment up front, give the 40 hours up front January 1st, employees still have accrued something in the event that an incident arises where they would need to use the sick leave. So the risk really, from a practical perspective, is in this first 6 months. What do we do between July and January, assuming that's your PTO year or your sick leave year? What do we do in this first 6 months as a company when we've already provided 40 hours or whatever, however many hours we've already paid them? Now we're paying them double, or in some instances, nearly double in the same year just to meet the sick time law. And I think that really ultimately will depend on a business decision contingent upon what that risk is for your organization, what your workforce looks like. Do you have a workforce that is working a significant amount of overtime hours where that accrual will be a significant expense for you? There really are various factors to take into account to make a really informed business decision in this respect. But the insight we've been getting from the Industrial Commission is somewhat, in some instances, a little bit counterintuitive than what we would presume. And so I think it's the exposure there. Absolutely, and so long as you're able to recognize it and really manage it and make an informed decision for your organization, then and mitigate that risk, I think you'll be in a good position. So it looks like we have just one final question that came in, and for anybody who's still hanging on with us, we're more than happy to answer this final question. The caller has asked for strategies that we may offer to curb employee abuse on scheduled work days that are holidays, since we can't ask for supporting documentation until day 3. So if employees are going to be getting sick, and this happens under the FMLA as well, people get sick on Fridays and Mondays, people get sick, the days leading up to the holidays that they can extend their time off. The way that the statute's written, you would be facing exposure if you either took an adverse action against an employee for using paid sick leave, or if you inquired into details that you're not allowed to get from them before they're out for more than 3 days. And so I think educating your population in terms of what this is really intended for, and staying within the confines of the law is going to have to be, the approach that you take. And certainly, I would hope that HR or legal would be available as a resource to help managers in ferreting out true attendance violations, separate and aside from sick leave violations, because there are real penalties and consequences for employers in this regard.
And one thing that you shouldn't do as an employer in that case, some questions I've gotten are, if somebody's going to call out, or be sick or need to be somewhere, during the busy season or, the day before a holiday, can we make them find a replacement and say, yeah, you can do this as long as you find somebody to cover your shift because we're really busy. You expressly cannot do that under the statute. You can't require anybody taking leave under this law to find coverage, essentially, for the time that they're going to be gone. So I think Marian's right that looking at this a bit more, at a 30,000-foot level and training your managers and sort of communicating this to your employees, is the best way to go. I mean, the statute says what it says, and if it's less than 3 consecutive days, the way the statute is written, you cannot request, documentation. So, there may be other issues associated with, employees that sort of regularly engage in that conduct that you may be able to manage or deal with, but at least, strictly speaking, under the language of this rule, that's what it says.
That's right. And I think there's one more point that's raised that's worth mentioning from a practical perspective is if you provide your employees with the required sick time up front, if you use that alternative, how do you handle employees that join you mid-year or months before the end of the year? Are you required to give them also 24 hours or 40 hours? Can you prorate that allotment? And the answer is, at this juncture, we don't know that you are allowed to prorate the allotment. Certainly, it would seem like a reasonable approach. Hopefully there's some additional guidance on that. In California, they did issue additional guidance about prorating, but I'll tell you that it didn't come out until about a year and a half after their law went into effect. And so this is an organic process, and you know, we'll kind of see how it develops. But our hope is to keep clients informed and to keep them from being test cases under this statute. So,
all right.
Yeah.
Well, I think those are all the questions that we received. And again, thank you very much for your attendance. For those of you who are still on, we appreciate it very much.
Take care.